If it may please the court, in this matter, appear with the Solicitor General, Mr. Kennedy Ogeto, who is here, Mr. Kamau Karori, Mr. Paul Nyamodi, Maurice Ogoso, Radik Arora, Faith Chalo, and Sharon Cherotich. If it may please your Ladyship, the Chief Justice, we have greatest respect for the order you have made, but we humbly request that if taking the court's diary into account, there is any possibility of adding a little more time so that each party and the public out there are satisfied that we have had an opportunity to properly highlight what is before you. It could only be in the interest of justice. We are not disputing your order. We are merely requesting. We know that it is within your discretion, but the discretion can be exercised in a manner that enhances the democratic process and the judicial authority of this court. As a final court on this very important issue, which will determine the future of this country absolutely. This decision will determine whether this constitution can ever be amended, or it is so rigid that it can never be amended. And that will determine the future of the future Kenyans. I humbly request that we look at this thing once more. But if the court is not determined to accommodate the parties, then I would request that you concede to a donation of time which the AG has got from the Speaker of National Assembly and the Speaker of Senate, who have indicated that in view of the gravity of this matter, they would rather donate their 15 minutes each to the AG to enable the AG articulate his case fully. But I humbly request that if possible, we accommodate everybody so that we have a determination made on the spirit of a representation which has provided an opportunity to every party. Thank you.
Thank you very much for those submissions. You'll give us...
Your Lord,
oh, there's someone.
This,
may I, my lady, Chief Justice, and the honorable members of the court, my name is Githu Muigai. I appear for IEBC with my learned friend, Mr. Eric Gumbo, Mr. Justus Munyidhia, Mr. Moses Kipkoge, and Ms. Wamboi Muigai, and Mr. Delbert Ochola. We have only one submission, which is to associate with my learned friend, Mr. George Oraro, in the plea for a little bit more time in which the parties who are entitled to address you may address you. In our case, we consider that 45 minutes may not be sufficient to argue a matter that has very broad implications, which is the quorum and the function of IEBC. If we have looked at the record in the High Court and the record in the Court of Appeal, and it's quite clear that very major errors of law and fact were made precisely because time was not sufficiently allocated. That is our plea, my lady.
Your Lordship, my name is Wambulwa. Your Lordship, my name is Wambulwa. I appear for the Senate and the Speaker of the Senate, who are the 14th and the 16th respondents. Your Lordship, as you have been told by my learned senior, this Senate and the Speaker of the Senate, together with my colleague, Mr. Kuyon, representing the National Assembly, and the Speaker of the National Assembly, were the main respondents together with the Attorney General at the High Court. Therefore, we find that the 15 minutes allocated to the parties might not be sufficient, as the respondents are addressing most of the issues raised. However, if the court, as requested, maybe is constrained of time and might not be able to accede to the request, as was said on behalf of the Attorney General, we believe that the Speaker of the Senate, who is the 14th respondent, is allocated 15 minutes, and the Senate, who is the 16th respondent, is allocated 15 minutes. In that regard, we will be obliged to donate 10 minutes to the Attorney General, if the court may allow, so that we remain cumulatively with 20 minutes to highlight our issues. Thank you.
My lady, in the matter, my name is Kuyoni, and I represent the National Assembly and the Speaker of the National Assembly. The Speaker of the National Assembly is the 13th respondent, and the National Assembly is the 15th respondent. My lady, I also join my colleagues and echo the sentiments that they have raised, that the Speaker of the National Assembly and the National Assembly were main respondents in both the High Court and the Court of Appeal. And we will also be requesting the court, my lady, that if, as it considers the time request made by my learned seniors, it also considers adding us a few more minutes. My lord, I represent two parties, the Speaker of the National Assembly and the National Assembly, and we were allocated 15 minutes, I think, for each party. And if that is the case, my lady, and the court is unable to see to the request for more time, we will be donating 10 minutes of our time, and my lady will be remaining with 20 minutes to highlight on our issues. Thank you.
It may please the court, my name is James Orengo. I appear for the 18th respondent and the 21st respondent, together with my learned friends, Mr. Paul Mwangi, Professor Ben Sihanya, my learned friend, Mr. Jackson Awele, Mr. Arnold Ochieng Oginga, Ms. Winfred Makaba. From our point of view, we fully support the remarks made on behalf of the two appellants, namely the Attorney General and the IEBC. It is our view that this matter should be fully ventilated. The matter, although being heard and considered by the court, but there's a great deal of public interest in this matter. The Kenyan people would want to know the arguments and the positions of the various parties as ventilated before the court. They don't have the privilege of having the written submissions. And my lady and the court, this is probably one of the most important cases that would ever come before the Supreme Court on the Constitution. Secondly, my lady, we appear for the two respondents. We filed joint submissions. In the submissions, you'd find that in respect of each respondent, the matters we are dealing with in respect of both respondents, some of them are common and others are not common. But I'd urge you that if you had to give the Attorney General and the IBC a little bit more time, then on our part, an additional 5 minutes. Since we are appearing for two respondents, would be appreciated. Since if you look at our written submissions, we are almost dealing with all the issues that are being raised by the appellants. So we'd pray that you give us 5 additional minutes, and And that will only be possible if the Honorable Attorney General and the IEBC are given a little bit more time. Thank you.
Thank you, Chief Justice and Counsel. This is for Senior Counsel Martha Karua and Mr. Uching Dudley. From the record, your clients were admitted as amici curiae on the 21st of January 2021, so that you entered the proceedings at the first instance as amici curiae. At the Court of Appeal, you are partly named as respondents. In one appeal, you are named as amici curiae. The question that I'm asking myself is, when does amici mutate, stop being a friend of the court, and the court is the court, and then become a party, either as an appellant or as a respondent? So that the question we're asking ourselves is, if you entered the proceedings, the dispute at the High Court as amici curiae, why are you suddenly calling yourselves respondents? Is it enough that the appellants call you respondents? Do parties create positions for themselves by suing each other outside the framework of the dispute before the court? And therefore, why is it in error for us to have said that you are amici right from the beginning until this court? That is where the issue would arise. And I think the error is admitted by the court, that in the directions we should have indicated that you were joined as amici not at the Court of Appeal, as the directions would be saying, but at the High Court on the 21st of January 2021. So my question is, how do you mutate from a friend of the court to an adversary of one of the parties, as you're saying? That is all we're asking.
If I may, in the Court of Appeal, we were cited as respondents and accused of being partisan. We responded, therefore, as respondents and tackled the issues as respondents. The same before this court, and nobody challenged that. I remember in the Court of Appeal, it was put to us in the allocation of time, but we did tell the court, having been dragged to court as respondents, we deserve time to highlight and defend our position. In these proceedings, it's exactly the same. And before this court, we made an application for consolidation, which cannot be made by an amici. The court treated us as respondents. Can the court then turn us into amici? Because before this court, we now come to defend our position just like we defended it in the Court of Appeal. But our position also is that regarding every party before the court, including interested parties, this being the highest court, nobody should be shut out. Everybody should be given a hearing. But we are respondents, that's the way we are named, and respondents also, once heard by the court, we are not opposing any party. It is because our submissions appeared to agree with the submissions of one of the respondents that the AG and the others cited us as respondents in the Court of Appeal. The AG avoided us in this court, but we see his last submissions are mainly responding to our submissions. We deserve a hearing. And we are asking the question again, how does an interested party, who then morphed into a respondent, just like us, get 45 minutes? And we don't mind her getting 45 minutes, but in contrast, we are shut out. Where is the equality before the law?
If I may also briefly respond to the question. We are victims of a situation which we have not created. The Court of Appeal Rules 2010 do not recognize amicus. I've appeared before you twice recently in the County Development Board's case, where a former amicus at the High Court was heard here as respondent. I also appeared before you in the Eric Gitari case, where a former amicus at the High Court ended up here as respondent and was given audience. That is the situation with all amici admitted at the High Court currently. And the other thing is this court's rule on amicus is that an amicus who is slanted to one side will have their submissions disregarded. So Jack Mimali right now risks being excluded from the oral arguments, and when you come to his written submissions, you'll find them supporting one side of the case. He also risks being excluded at that level. That danger can only be mitigated by allowing him about 10 to 15 minutes to highlight what his case is about. Thank you.
Thank you very much. We will consider those submissions on the allocation of time, and we'll be back after 20 minutes to proceed.
Marukia. Submissions. Ziletwa huko. Sawa.
May I have your attention, please? Can we be seated so that we begin? Councils, please, may you be seated so that we begin? Please.
Thank you very much. I'm sorry for keeping you waiting. We have considered the requests by the various council for us to consider increasing the time allocated in the directions. And we have accommodated that request, and we wish to inform you that each party will have now 15 more minutes. We have also considered the request to donate time by some of the parties, and that will be also around. But the party will have then to deal with the time left strictly, having donated the rest of the time. The request by, there is also another issue we wish to clarify about the 72nd respondent, Philista Wakesho, who made an application before the High Court to be made an interested party. And she was, our directions is that she made that application as the Deputy Secretary General of the Third Way Alliance. Therefore, the time, the 1 hour allocated to the Third Way Alliance parties, that is the 7th and the 9th, will be shared with Philista Wakesho. So our time is not 45 minutes, but 1 hour to be shared with the Third Way Alliance because they were pursuing the same issues in the High Court. As regards the participation of the Amisi Culi who are joined in the High Court, the position of this court is that they remain Amisi, friends of the court. We will consider their submissions and also whatever submissions were done in the High Court and in the Court of Appeal, we will not allow them time to submit. Those are the further directions of the court. We were told that we need to give this matter all the time, and we agree it is a very important matter. But we have also done research. Supreme Courts all over control their own proceedings and give time allocation. And we have also considered the case that was cited by Senior Counsel Dr. Kaminwa in India, the case, Sanavande case, which was heard for 69 days. We've also looked at the Supreme Court rulings now of the Supreme Court of India. There is time allocation. That was a long time ago when there was no technology, no written submissions. Now we have written submissions. It's only a matter of highlighting the submissions. So we'll give you the time to do the highlight, and we'll read the record of appeal that is before us and whatever was in the other courts. That said, we will now proceed to hearing by calling the first appellant's case, who has 1 hour, and you can indicate the time that has been donated to you so that it's all put together.
Most obliged, we seek leave to withdraw since we have no role.
It's leave granted. Is that the first appellant's case?
My Lady, the Chief Justice and President of the Court, my Lords and my ladies, good morning. May I begin by thanking you, my lords and my ladies, for the opportunity to appear before you and to make these submissions on behalf of the Honorable the Attorney General. And for the record, my name is Kennedy Ogeto, the Solicitor General. And just to confirm, my lady, my lords, you have given us an additional 15 minutes. The Speaker of the National Assembly and the Speaker of the Senate had also donated 10 minutes each. So in total, my understanding is that we have 35 minutes in addition to the 45 minutes that we had originally been allocated.
That is correct.
Many thanks. This appeal raises a number of important legal and constitutional matters. But in our view, my lady and my lords, these issues principally revolve around two main questions. The first question is, what is the import of our written constitution? And the second question, how much and to what extent can we imply meaning into constitutional provisions that are, in our humble view, otherwise conclusive and unequivocal? Our appeal does not just seek the answers to these questions, it also seeks, with equal anxiety, the justification for the answers, whatever those answers may be. Our singular desire in this appeal is that the lingering legal and constitutional questions in this appeal be determined and settled by the highest court in our land, not just for today, but also, and perhaps more importantly, for posterity. Through our oral and written submissions, we contend that the learned judges of the Court of Appeal answered important questions the wrong way, and that they had the wrong, often ambiguous, and in some cases contradictory justifications. It concerns the applicability of the basic structure doctrine in Kenya. We submit, my ladies and my lords, that the learned judges erred in holding that this doctrine applies in Kenya. At the outset, we have no doubt that our Constitution has a basic structure. No one can deny that all constitutions have some basic structure. We submit that in our case, that basic structure is outlined in Article 255(1) of our Constitution. Our Constitution tells us that it is amendable. It also tells us how it should be amended. It does not impose any limit to its amendability. And yet the learned judges of the Court of Appeal are in agreement, erroneously we submit, with the High Court that the basic structure of the Constitution is amendable only through the primary constituent power, which must include four sequential processes, namely civic education, public participation, constituent assembly debate, and ultimately a referendum. With tremendous respect, we disagree with this position. Neither our Constitution nor its history contemplate the doctrine. We agree with the learned judges of the High Court and the Court of Appeal that Kenya has had a history of indiscriminate constitutional amendments. We, however, note that the people were fully conscious of this while making the new constitution. Page 73 of the final report of the Constitution of Kenya Review Commission, CKRC, captures this concern, and I quote, "Considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new Constitution from a similar fate?" End of quote. And I underline the words quickly and fundamentally. And this report is available in volume 13 of the Bundle of Authorities at page 1753. I have to emphasize, my lords and my ladies, that a plain reading of this report clearly indicates that the problem that was identified during our 2010 constitution-making process had two components to it: quick amendments and fundamental amendments. Page 75 of the final CKRC report identified the people's solution to this problem, and I quote, "A distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions." End of quote. This solution is given effect in Chapter 16 of the 2010 Constitution. The procedure for amending the entrenched provisions, which is the basic structure, is elaborate and onerous. Our humble view is that judicial intervention ought to be limited to confirming that this consciously elaborate and onerous constitutional procedure is strictly observed and followed in amending the Constitution. The learned judges of the Court of Appeal erroneously elevated the basic structure doctrine to a universal template for certain constitutional amendments or change. This fails, my lords and ladies, to recognize that constitutions are not identical. In our humble submission, where a constitution creates an amendment power that is similar to the exercise of the primary constituent power by being inclusive, deliberative, and democratic, such as is the case in our Constitution, the basic structure doctrine has no place. Problematically, my lords and my ladies, the learned judges do not agree on what the basic structure is. In paragraph 474G of its judgment of 13th of May 2021, the High Court had told us that what constitutes the basic structure will be determined on a case-by-case basis. In the Court of Appeal, Lady Justice Nambuye, for instance, states in paragraph 62 of our judgment that the basic structure of the Constitution is, quote, "the Constitution itself and what it contains," end of quote. Lady Justice Okwengu, on the other hand, at paragraph 82 of our judgment, expresses the position that, quote, "the framers of the Constitution either consciously or unwittingly identified the basic structure of our Constitution through Article 255, end of quote." According to Justice Kiage, at page 85 of his judgment, Article 255 of the Constitution, quote, "either coincides or nearly coincides with what may be considered to be the basic structure of our Constitution," end of quote. Finally, Justice Cairo and Justice Tuyot are certain in their respective judgments that Article 255 of the Constitution outlines the basic structure of our Constitution. Even if the basic structure doctrine was applicable in Kenya, which we dispute, the absence of clarity on what the basic structure is would create much legal and constitutional difficulty. This is a matter that we humbly urge this court to clarify with finality. The second issue I wish to highlight relates to the question of the remit of popular initiative in the constitutional amendment power under Article 257 of the Constitution. In our view, The provision does not discriminate as between private citizens and public or state officers. The route is available to registered voters, who obviously include the president and public or state officers. Our study of the history of this provision is that the popular initiative route was meant to curb the monopoly of Parliament on matters constitutional amendments. It was not meant to exclude certain registered voters or citizens because of their positions or standing in society. And here we rely on the final report of the Technical Working Group, K, of the Constitution of Kenya Review Commission on Constitutional Commissions and Amendments to the Constitution, which recorded as follows, and I quote, "The committee introduced a novel idea called popular initiative. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament," end of quote. And that report is available in volume 18 of our bundle of authorities, page 2622, and the quotation will be at page 4 of the report. Again, my lords, my ladies, the learned judges do not agree on the implications of their finding that the president cannot use the popular initiative route to amend the Constitution, or the options available to a president who may wish to spearhead constitutional changes. In paragraph 490 of its judgment, the High Court told us that the president can use the parliamentary initiative route through the Attorney General. Justice Musinga agrees with this position in paragraph 347 of his judgment. Lady Justice Nambuya in paragraph 99 of our judgment, and Justice Cairo in paragraph 81 of his judgment agree as much. On his part, Justice Kiage holds in paragraph 109 of his judgment that the president is under duty to obey but not change the Constitution. So according to Justice Kiage, changing the Constitution is tantamount to disobeying the Constitution. Lady Justice Okwengu, Lady Justice Sichale, and Justice Tuyot do not express themselves on these matters. This absence of clarity, my lords and my ladies, is clearly problematic. In addition to the foregoing, the learned judges do not consider the consequence of their finding to a president who, having been elected on the platform of arguably necessary constitutional reforms, finds himself facing a partisan and hostile parliament, perhaps because he has a minority in that parliament, or because he was elected as an independent candidate. Justice Kiage, the only one who expresses his view on this point at page 109 of his judgment, terms this situation as hypothetical. We humbly submit, however, that such situations are a real possibility under our constitutional architecture and therefore require contemplation and an answer which we call upon you, my lords and my ladies, to provide. The third and last question, which I wish to briefly highlight, relates to the question of presidential immunity from civil court proceedings. And here the majority in the Court of Appeal held that civil proceedings can be instituted against the president during his tenure of office in respect of anything done or not done contrary to the Constitution. I wish to highlight two obvious problems with this. First, in order to determine whether the president has done or not done anything contrary to the Constitution, there has to be a judicial process. And this defeats the whole essence of immunity, as the president would have to participate in the process to prove his innocence. Second, immunity from legal process recognizes, as a matter of common sense, that the holder of immunity, in performing his functions, engages in conduct that may expose him or her to legal process. If therefore there was the expectation that the office holder's official conduct must always be perceived as lawful, then the whole question of immunity would be redundant. My lords, my ladies, my other colleagues, acting for the Honorable the Attorney General, shall endeavor to demonstrate to my lords and my ladies additional problems with the findings of the learned judges of the High Court and the Court of Appeal. At this juncture, may I, with your permission, lords, my ladies, invite Senior Counsel George Oraro, followed by Mr. Kamau Karori to present the arguments, and Mr. Nyamodi will deliver our rejoinder at the end of the proceedings. Many thanks and most obliged.
Thank you, Chief Justice, members of the court. The Constitution of Kenya commences with very powerful words, and that is, we, the people of Kenya, acknowledging the supremacy of the Almighty God of all creations, and exercising our sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this Constitution, adopt, enact, and give this Constitution to ourselves and, more importantly, to the future generation. Article 1 of the Constitution thereafter contextualizes the sovereignty of the people and further asserts that this sovereignty can be exercised either directly or indirectly at Article 1(2). The people of Kenya have further delegated their power to state organs, including the judiciary, as specified in Article 1(3). But the exercise of such delegated power must be strictly in accordance with the Constitution. In the result, the people of Kenya, by their constitutional text, reserved the sovereign power to be exercised directly where it has not been delegated or it is not being exercised through democratically elected representative. And it is in this context that in the CKRC report at paragraph 744, and that is found in volume 13 at page 1851 of our list of authorities, at paragraph 7, they state as follows: all power and authority should derive from the people of Kenya, and the people should be governed through their will and consent. The people reserve to themselves all the power and authority that they do not expressly delegate to the state and its organs. So ours is a participative constitution in which the people are fully involved. It was on that account that in formulating the provisions for amendment of the Constitution, it was recommended at paragraph 746 of the CKRC report, and you find this in page 851, volume 13 of our list of authority. They stated that a number of key constitutional issues should be enshrined in the Constitution, that they should be amended only by a referendum, so that a referendum in accordance with the Kenyan Constitution, as mandated by the people, was an exercise of sovereign power and not a delegated power. It is not strange that that has been incorporated into our Constitution, and indeed, in the famous case which has been relied on to justify the basic structure doctrine, the case of Njoya, it is always stated that at that stage the basic structure doctrine was recognized, but Njoya also recognized the textualization of the sovereign power. And you'll find that in our list of authority at page 24, where in Joya, this is what Justice Ringara found. The second stop is recognition that sovereignty of the people necessarily betokens that they have a constituent power, the power to constitute and or reconstitute, as the case may be, their framework of government. That power is primordial one. It is the basis of the creation of the Constitution, and it cannot therefore be conferred or granted by the Constitution. Indeed, it is not expressly textualized by the Constitution, and of course it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they would do so only ex abundante cautela. And that is what they did in our Constitution. This case was in the repeal Constitution, and in the new Constitution, they now ensured that they textualize the sovereign power of the people. The Constitution of Kenya thus places the people and the exercise of their sovereign power at the core of constitutional operation and enforcement. And for that purpose, it incorporates a very permissive amendment provision under Article 250, granting the courts the power to advance the contemporary aspirations of the people, with this court as the final arbiter. And that is where we are. The direct democracy, which is referred to at Article 1(2), is exercised through the national values and principle of governance pursuant to Article 10, public participation in legislation for Parliament, Article 118, and for county assemblies, Article 196, and finally, in constitutional making through popular initiative, that is Article 257, and of course, public discussion in amendment by Parliament at Article 256(2), and finally, that sovereignty is exercised through a referendum to amend those matters which have been specified at Article 155(1) by the provision of Article 255(1) by the provision at Article 255(2). It is because of this peculiar character of our Constitution that this court, in dealing with the amendment power under Article 259, had the following to state in its decision in petition number 13A of 2014, Judges, Magistrates Vetting Board, and 2 others versus Center for Human Rights and Democracy, and 11 others. This is what this court had to state. It stated that although certain jurisdictions such as India and Germany have perceived judicial review as an immutable structure of their constitution, and hence the basic structure doctrine, these jurisdictions do not have constitutions that are as unique as Kenyans. We must ask whether these foreign jurisdictions we seek reliance upon have constitutions, and if they do, whether these constitutions have provisions akin to Articles 123, 159, and 259, and I would add to that 257 and 255, which emphasize the sovereignty of the people, or whether they have principles and values like the ones found at Article 10, which apply to the interpretation and application of the Constitution's historical context into the interpretation of the Constitution. If the answers to those questions are in the negative, and indeed they are, then the common law doctrines found in other jurisdictions, foreign cases, and foreign constitutions must be interpreted in such manner as to reflect our modern constitution and our unique conditions and needs. And that's what I'm requesting this court to do. Look at this purported introduction of limitation to the Constitution by a foreign doctrine and find out whether in the context of Kenya today, this doctrine can apply to what the people had determined to be applicable to them. That notwithstanding, both the High Court and the Court of Appeal found that there is a limitation to the constitutional amendment powers under Chapter 16, Articles 155, 156, and 157, read together with Article 1 and with very permissive provisions under Article 259. The said finding was based on the following grounds. First and foremost, the court found that the basic structure doctrine is accepted in Kenya following the decisions in the case of Njoya and Attorney General, the case of Onyango and 12 others versus Attorney General, and you will find that at page 28 to 121 with the relevant portions of the judgment at pages 67 of volume 1 of the Attorney General's authorities. These were all cases decided under the repealed Constitution, and I will go to that in detail, but I would start by commenting that under the repealed Constitution there was a single tract amendment provision which placed all the power on the Parliament to affect amendments. Under that Constitution, Parliament was purporting from time to time to overturn the basic structure without reference to people, and therefore, in that context, the basic structure doctrine applied. But does it apply in our current context, which has a multi-tract amendment provision, as we will show you? The other decision they relied on was decision in Commission of Implementation of the Constitution versus National Assembly of Kenya and two others. It was a decision by my learned judge when he was in the High Court, and it was based on an attempt by Parliament to alter a provision which was entrenched under Section 151, and the issue there was limited to the power of Parliament to amend. Now, contrary to those decisions, the courts subsequent to the amendment of the Constitution and before the decision in this case, in the case of Priscilla Ndululu Kivuitu and another suing as personal representative of Samuel Mutua Kivuitu and Kiara Mutu, my ladies, you find that at page 142 to 182 and at page 177, found that the basic structure doctrine is not applicable to Kenya in view of the amendment provisions under the new Constitution. Though this finding was obiter, but that was the finding of the court, 3 judges. You find that at page 142 to 182, and the relevant finding is at page 177, volume 2 of our authorities. The Court of Appeal has been more succinct, and in the case of Senate and 48 others versus Council of Governors and 54 others, 2019, you find that at page 183 to 202, at page 154 of volume 2 of our list of authority, they expressly found that Kasavananda no longer applies to Kenya in view of the new Constitution, a bench of 5. Again, in the case of Attorney General and another versus Randun Zai, Rua, and five others, they came very succinctly and expressly, and now clearly stated that all the provisions of the Constitution were amendable so long as Article 255, 256, and 257 are followed. And you will find this case in our supplementary bundle. The relevant finding is at page 19. Due to time, I will not read it, but if I get a little time, I'll go through it. Now, following that, there was clearly a contradiction between the position now held by the court in this case and the earlier decisions made by the Court of Appeal, which were never distinguished in their decision. It now falls upon you as the final court, and the court granted this power to reconcile these contradictions and come up with a very clear position whether there is any limitation to amendment power as granted under the Constitution. My humble submission is that there is not, because as the SG had stated, the provision of amendment under the Constitution are very clear. The other ground which they relied upon was that an amendment provision in a Constitution are secondary powers granted by the exercise of primary constituent power and cannot therefore alter or amend what has been created by people exercising their primary constituent power. This is based on a constitutional doctrine which was later advanced to the doctrine of basic structure as articulated in the case of Kesavananda in India. However, the Kenyan Constitution has distinguished between the matters which can only be amended by Parliament or popular initiative followed by referendum, and those which can be amended by Parliament and therefore not listed under Article 255(1). The Kenyan Constitution provides a strict procedure for those matters which have been entrenched under Article 255(1), and which can only be amended whether by Parliament or popular initiative, but through a very intensive process involving consultation with the people, and that's the only place in the Constitution where the issue of public discussion is incorporated. Article 256(2) requires that before Parliament passes any constitutional amendment, there has to be publication and public discussion. And that's not the end. Parliament has then to pass it with requisite majority, and it is only after it is passed by that requisite majority that it is then taken to the people for a referendum. And that referendum has a threshold higher than presidential elections. It is therefore clear from those provisions that people are not only involved in a referendum, but they are involved from the onset, from the setting up of the bill for the constitutional amendment. They must be consulted and they must discuss. And it is upon that consultation and discussion that it can then now be passed by Parliament. And if Parliament passes it, then the final stage now becomes the referendum. This is a process which doctrinally has been recognized in constitutional theory and applies in all cases where the design of a constitution contains this type of structure. And it is referred to in the book Making, Breaking, and Changing Constitution by Professor Richard Albert as follows. You find that book at volume 18, pages 2527 to 2530. And it says this: the comprehensive multi-track pathway is designed to avoid the problem of obstruction by distributing amendment power to different actors. The designers can create different procedures for amending the Constitution and others for dismembering it, the former requiring a lower degree of agreement than the latter. What emerges is a hierarchy of constitutional importance, with some parts or principles of the Constitution assigned to amendment procedures and the others to dismemberment procedures. And that's what our Constitution has done by Article 255(1) and 256. Yaniv Rosnai, in his part, in his book on constitutional amendments, found at volume 2, page 15 for it states as follows. Constitutions have different procedures for constitutional amendment. Not only do entire constitutions differ from one another in their mechanism, actors and procedures involved in the amendment processes, but also the same constitution might incorporate different procedures for amending different provisions and principles, like ours. This section therefore argues that one ought to regard constitutional amendment powers not in a binary manner, limited or unlimited, as the Court of Appeal and the High Court have done, but rather as a spectrum of a scope of amendment powers. The more similar the democratic characteristics of the secondary constituent power are to those of the primary constituent power, strong amendment power, the less it should be bound by limitation, including judicial scrutiny and vice versa. Yaniv himself, the guardian of basic structure doctrine, says that if the amendment power has incorporated a democratic process which ensures that people are in some types of amendment involved in participating in the process, then the courts should not interfere. The same is confirmed by Rosalind Dixon and David Landau, who in his case, Transnational Constitutionalism and the Limited Doctrine of Unconstitutional Amendment, state at volume 18, page 2498, another way in which the problem of abusive constitutional amendment can be dealt with at the level of constitutional design is via the use of some form of tiered amendment procedure. A system of a tiered amendment threshold has become as part of comparative constitutional state of the art. Many new constitutions include different amendment rules for different parts of the Constitution. That is what our Constitution has done. Yet, we are now being restricted to operating the Constitution in the context of decisions predicated on a single track amendment power under the repealed Constitution. Indeed, the tiered amendment provision was what was recommended by the CKRC in their recommendation, and then included in Article 1 and 255.1 and 255.2. Now, the third issue which was raised in support of that position was that the word amendment is restricted in scope and can only mean limited correction and or modification within the existing structure of the Constitution without fundamentally changing its nature in the Kenyan Constitution. The word amendment in the Constitution cannot be the only word which is fixed in stone under this Constitution despite Article 259. It has to be read in the context of Article 255, which provides on how amendment is provided, Article 256, which gives the role of Parliament, Article 257, which gives the roles of popular initiative, and people's participation and discussion and a referendum as incorporated in this article. Read in that context, it is beyond what is being said. Now, does the court have power to review amendment provisions? My humble submission is that the court has powers, but that power is limited to ensuring that the provisions are restricted to what has been provided for under the Constitution. Can the court prescribe the manner in which constituent power can be exercised as it did in this case? It is an accepted constitutional principle that primary constitutional power can neither be regulated nor restricted. It is contended by Professor Richard Albert that there is power to revert to the original configuration where a constitution does not provide the provisions for its dismemberment. And he calls this the principle of mutuality in his article, Constitutional Amendment and Dismemberment. But this can only happen as a default provision where the Constitution does not provide for the amendment of those entrenched provisions of the Constitution. However, it is not in accordance with the constitutional principle of not interfering on primary constituent power, because it creates an extra-constitutional nature, thereby regulating the constitutional procedures which the people have and which is unlimited. And you will find this in an article by Yaniv Rosnai called Constitutional Amendment and Fundament. It is at page 2620, volume 10 of our list of authority. In conclusion, the basic structure doctrine is a constitutional theory which limits the amendment powers by the secondary constituent power. The doctrine, however, cannot be invoked to override an express design of a constitution which incorporates the power of the people through a multi-track amendment procedure in which they participate. This is what has been incorporated in our Constitution by Chapter 1, Chapter 16, Article 259, and particularly provisions of Article 255, 256, and 257, a strong amendment power for that purpose. In my humble submission, I therefore submit that the learned judges, both in the High Court and the Court of Appeal, erred in finding that the basic structure doctrine applies to Kenya. I'll very quickly go through issue number 7, and that is whether interpretation of Article 257.10 of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separated and distinct referendum questions. And on this I say, the said articles require that a bill for a matter specified under Article 255.1 proposing an amendment to the Constitution be submitted to people in a referendum. It is provided that before assenting to such a bill, the President requests the Independent Electoral Commission and boundaries to conduct a referendum for approval of the bill. What is submitted is not a question, but the bill, either to be approved or not approved. The rules under which these have to be carried out are required by law to be articulated by Parliament, and that is at Article 82(1)(d). The only legislation currently dealing with referenda is Section 49 of the Election Act, which places the burden on the IBC to frame referendum question or questions to be approved by National Assembly. It would be a usurpation of the power of Parliament and IBC for the court to prescribe the manner in which a referenda and questions can be carried out. That is left to IBC. However, it is within the court's power to intervene if it is carried out in a manner that does not conform with the Constitution. Indeed, a referenda is not being carried out for the first time in Kenya. We have done so both under the WACO draft and the current Constitution, which had many articles. The critical issue was whether there had been sufficient civic education and public consultation, and that is where the court comes in. Issue number 5, the place of public participation under Article 10 vis-a-vis role of IBC. I would like to say that popular initiative only commences when signatures have been submitted and approved by the IBC. And from there is very intensive public consultation as the matter passes through county assemblies and Parliament, and mandatory public discussion by Parliament, and eventually there is mandatory civic education by IEBC under Article 88. It is through that process that the people are informed of what is contained in the bill and what they need to submit on. With that, I humbly submit that the Attorney General's appeal should be allowed and the Court of Appeal decision on the subjects I've talked about be set aside. I only would like, before I leave, to confirm that I agree with the finding of the Court of Appeal on the issue of public participation on the public initiative, that there was sufficient evidence of what had been carried out by the BBI team, and there was no evidence to controvert that, and therefore the respondents had failed on their claim that there had not been public participation on the popular initiative at the signature stage. Thank you. I'm very grateful for your listening to me. I'll hand over to my learned friend, Karori Kamau.
May it please, my lady, the Chief Justice and judges of the Supreme Court. It's my pleasure to appear before you this morning. I will be dealing with 3 issues that were identified by the court. The first issue is regarding the question whether the president can be sued for actions taken by him or not taken by him in accordance with the Constitution. I will then be dealing with the question of whether the second schedule to the Constitution of Kenya Amendment Bill 2020 was unconstitutional. And finally, I'll be dealing with the question of whether the president can initiate the process of popular initiative. My lords and my ladies, we have filed our submissions. The AG submissions on the issue of the presidential immunity, which is the first issue that I will deal with, is found at paragraphs 93 to 120, which is pages 23 to 29 of the submissions dated the 24th of November 2021, and paragraphs 59 to 85, which you'll find at pages 19 to 26 of our supplementary submissions dated the 14th of January 2020. Now, the issue that is posed before you, my lords and my ladies, is the question of whether the president can be sued in his personal capacity for acts taken by him in the course of discharging the functions of his office. And I think to lay the background to this, to our answer to this question, it's important to understand why is it that the Constitution at Article 143 granted the president immunity. And the first thing that you will notice in Article 143 of the Constitution is that it is headed protection from legal proceedings. So that the whole essence of Article 143 is to protect the holder of the office of the president from legal proceedings during his tenure of office. Now, what is not in dispute is that the provisions of Article 143(1) immunize the president from any criminal proceedings, whether during the time which occurred during the time that he was in office, or even the continuation of proceedings in relation of matters that occurred prior to his assumption of the office of the president. Now, what, however, is in contention is the provisions of Article 143(2), which relate to civil proceedings. Now, my lords and my ladies will notice that Article 143 is worded that civil proceedings shall not be instituted in any court against the president or the person performing the functions of the office during their tenure of office in respect of anything done or not done in the exercise of their powers under this Constitution. Now, my lords and my ladies will find the functions of the president are set out in Article 132 of the Constitution. So starting from Article 131,
it gives what is the authority of the president and gives various roles that the president plays, including that he's the head of state and government. He is also the commander-in-chief of the Kenya Defense Forces and so on. But critically, because I'll come back to this issue, at Article 131, 1D, he is also the chairperson of the National Security Council, which is in charge of ensuring the security of this country. Then the functions, as I said, are set out in Article 132 of the Constitution. Now, it is also important, my lords and my ladies, to note the provisions of Article 135 of the Constitution, which says every decision of the President in the performance of any function of the President under this Constitution shall be in writing and shall bear the seal and signature of the President. So that the actions we are saying are undertaken by the President in the discharge of the functions of his office under Article 135 are in writing and bear his signature and seal. And anything that does not is not in writing and bearing his seal is not a decision that has been made by the President in the discharge of the function of his office. So that, for instance, the President cannot declare that he has appointed a minister without that being put in writing and bearing his signature and seal. Why this is critical is because it informs the discussion that we'll be having regarding the immunity granted to the President. Now, my lord, this country has adopted a system of governance that requires 3 arms of government to operate independently but effectively. All 3 arms of government must perform their duties but must operate effectively. And that includes the executive, which is headed by the President, and the legislature, which is headed by the speakers of the 2 houses, and then the judiciary. So in determining this question, why was it necessary for the President to be granted immunity under Article 143(2) of the Constitution? And my lords and my ladies, the answer is simple. First, it is necessary that the President has decisional freedom to make decisions that are key and important to safeguard the interests of the country. He occupies a unique position in which on a daily basis he has to make decisions that affect the lives of Kenyans. And my lords, if the President is detracted because of the fear that every decision he makes may attract civil liability against him, it would have a chilling effect on the ability of the President to make decisions that are important for the purposes of the people of Kenya. And a case in point, because I don't want to make this abstract, a case in point is, for example, the lockdown following the emergence of the coronavirus in Kenya. Now, my lord, at that time, it is common knowledge that worldwide, the information regarding how this disease spreads was very limited, but the President has to make a decision immediately. The consequence of that decision and the consequence of the lockdown is that there are financial and economic effects on many people. Now, can the President be sued if it turns out much later that, in fact, it was not necessary to lock down the country? If that was the case, no president would, when faced with a situation such as that, order the lockdown of the country, even if it's for the benefit of the people, because of the fear that he may be sued and found personally liable for the actions that he has taken. And it is precisely because such events occur all the time that the President is immunized from liability. The second one, my lords and my ladies, and it's a critical one, is that in many instances the President may also have to make decisions that affect the national security of this country, including taking steps against enemies of this country, both foreign and domestic. And from our recent experience, we know that there are many instances where we have enemies of this country that are domestic. Now, my lords and my ladies, if it was possible for the President to be sued for the steps that he takes in those circumstances, you can imagine a situation where the President has to defend himself, and there is an application that is made for discovery as to why he made the decision that he made. Or, for the purposes of defending himself, he has to disclose the basis on which he made the decision that he did, whether right or wrong. My Lord, there are many people, enemies of this country, that would be very happy to receive information as to how the President makes his decision and who gives him that information. That would be inimical to the interest of this country. And it is for that reason that the immunity provisions in Article 143(2) are given. And my lords, as I wind up on that issue, it's also important to remember that invariably the president, because the appointment of the president in this country is through a competitive process, every time the president takes office, there are people who don't agree with some of the decisions that he makes for political reasons. If it was possible for the president to be sued for every action that he takes, there would be many people who don't agree with his decision for political reasons that would be filing cases against him, that he must then dedicate time and resources to defend himself, so that in the process, my lord, he is then detracted from his core business of carrying out the function of his office for the benefit of the country. And so, my lord, to avoid subjecting the head of state to these kind of suits, that is the whole purpose of Article 142.3, which protects the president from proceedings during the time that he is president. And my lord, the last issue that I just want to comment on that, granted this immunity to avoid a situation where the head of one arm of government, that is the president, is then appearing before another arm of government. And my lord can imagine the specter of the president being required to attend proceedings before courts of law. And the question that my lord arises, and we have raised it in our submissions, is what would happen if a finding of liability is made during the time during the tenure of the presidency? Can the court then issue, for example, warrants against the president? Can attachment be undertaken against the property of the president? It is to avoid those situations that Article 142.3 was put in place. And so, my lord, the Court of Appeal completely erred in its interpretation of Article 143.2 of the Constitution. I will not repeat what the learned Solicitor General said, but I agree entirely with him that what the Court of Appeal and the High Court was suggesting is that it is possible to demarcate between those suits that genuinely raise a situation where the president has acted outside of his powers under the Constitution and those that have not. Invariably, given our system of dispute resolution, it would require first that the suit is filed, the president engages a lawyer and defends those proceedings with the possibility that at the end of those proceedings it might be found actually he acted within the confines of his power, but by which time the immunity has already been rendered superfluous. And that is why, my lord, the artificial distinction between what the court referred to, that there's a certain action that have been taken outside the confines of his power and the others, my lord, becomes difficult to rationalize. And my lord, the fact that under Article 142 of the Constitution, there is no distinction, there is no period, there is no similar provision as Article 143.3, which then says the president can be sued in respect of certain matters after he leaves office, and I'm coming to that. In Article 143.2, there is no similar provision saying that after he leaves office, then he may be sued in respect of certain actions that he took. And that is deliberate. And going to Article 143.3, my lord, it's a humble submission that the Court of Appeal either did not interpret the provisions of Article 143.3, or where they did, they got it wrong. And my lord, I say this for this reason. If you look at the provisions of Article 143.3, they provide, my lord, that the president may be sued in respect, or sorry, they suspend the period of time within which proceedings can be brought against the president. And just for clarity and for record, it says where provision is made in law limiting the time within which proceedings under clause 1 or 2 may be brought. Now, this is the civil proceedings. Now, my lord will realize that the only statutes that deal with suspension of time for purposes of bringing proceedings are limited to private law. So we are looking at the issue of tort, we are looking at contract, we are looking sometimes into issues in land law. Those are the only circumstances under which time is suspended. In public law, there is no suspension of time. Under the Constitution of Kenya, you cannot plead limitation of time in respect of anything brought under the petition. And so, my lord, you can see that the Constitution deliberately carved out private actions by the president that have nothing to do with the discharge of the function of his office, and those are the actions those are the suits that can be brought after he leaves office. And my lord, this answers the question the hypothetical question that was posed by His Lordship Justice Kiage about what happens if the president's dog bites somebody. That has nothing to do with the discharge of his official functions. Correct. Or what happens if, in the course of demarcating his land, he encroaches on somebody else's land? All those, my lord, the position is that that suit can be brought, but after he leaves office. He cannot be sued during the time that is in office. That is the whole essence of Article 143.3. The question then may be posed, are you saying that in respect of anything that he does under the Constitution that is violative of the Constitution, he's completely immunized? That's not a submission by the Honorable Attorney General. We are saying, my lord, that this particular Constitution is very elaborate on the options available to a Kenyan who feels that any right that is enshrined in the Constitution or the Constitution itself is under threat. Article 165 of the Constitution. My lord, my lady, we had an additional 20 minutes that had been donated to us.
That is so.
Yes. So, my lords and my ladies, we are saying that, my lord and my ladies, that Article 22.1 of the Constitution, as read together with Article 23 and Article 165 of the Constitution and Article 258.1 of the Constitution, allow anybody to file proceedings in any court in seeking public law remedies in the event that there is any action that has been taken by the President or the Executive or anybody else that is violative of the Constitution, so that there is no lacuna in the form of the remedies that are available for anybody who feels that his rights or the Constitution itself is under threat of being infringed. And my lords, it is common ground that many suits have been filed challenging decisions by the President, including the example that I gave about the lockdown during the coronavirus. The Law Society of Kenya and its chairman went to court, and they managed to get an order saying that lawyers are also emergency workers, and they are entitled to also move around the country. So there is effective remedy available to anybody in the event that the President acts in violation of the Constitution or takes a step that is not allowed under the Constitution. The question then is, if there is an effective remedy in the Constitution to deal with situations where he strays out of the Constitution, what is the reason for wanting to name him personally? What is the purpose that will be served in naming him in the proceedings other than to embarrass him? And that is where, my lord, we urge that the court finds that in the circumstances of this case, A, there is sufficient remedy and effective remedy against circumstances where there may be claims that the President has acted outside of his powers, and that, my lord, in those circumstances, and the authorities that we have referred to you on this, the respondent in such proceedings is the Attorney General, not the President himself. There is absolutely no purpose that is served in suing the President in his personal name and requiring him to defend those proceedings using his resources. My lord, it's our submission, therefore, that the Court of Appeal disregarded the purpose of Article 143. And, my lord, for those reasons, we urge you to find that under the provisions of Article 143 of the Constitution, the President cannot be sued in his personal name in respect of anything that is done or not done in relation to the Constitution, and that in respect of private actions, that suit can only be filed after he leaves office. And so, my lord, just for the avoidance of doubt, we have said that the AG is not advocating for absolute immunity. We have shown circumstances under where suits can be brought to challenge executive decisions, but not to file them in the name of the President himself. Very quickly, my lord, I'll move on to the issue of popular initiative. There's a lot, my lord, that has been said on this. The AG has opposed the Court of Appeal's finding, and you'll find this at paragraphs 53 to 65 of his initial submissions dated 24th November 2021, and paragraphs 29 to 38 of his supplementary submissions dated 24th January 2022. But let me start off on this issue by saying this. The provisions of Article 257 of the Constitution that deal with popular initiative are not engaged until after the 1 million signatures of registered voters have been obtained. Prior to obtaining those signatures, there is no popular initiative. And so the steps prior, the actions that are taken prior, cannot constitute the popular initiative. The engagement of Chapter 16 for purposes of the popular initiative is in relation or only arises once the signatures have been obtained. And so, my lord, a lot of the discussion that was held before the Court of Appeal and the High Court was in relation with the steps that preceded the collection of the 1 million the signatures of the 1 million registered voters. My Lord, if you look at Article 257 of the Constitution itself, it does not prohibit the President or anybody else from getting involved in the process of popular initiative. And I must say this, my lords and my ladies, there seems to be an issue with people saying that don't just read the text of the Constitution. And my lord, the danger with that is that we may reach a stage where we now disregard what the people specifically said and try to read meanings into what they stated in the text. I think it is important that the beginning point in considering the provisions of the Constitution, the beginning point itself is the text. And in this case, the text does not admit of an exclusion of the President or anybody else from the process of popular initiative. But what is more of concern to us, my lord, is that in both the decisions of the High Court and the Court of Appeal, the President appears to have been stripped of some of his constitutional rights under the Constitution. Because, my lords, it is said that the President, as President, does not have the right to participate or even to initiate the popular initiative, meaning, my lords, that the right that the President has under the Constitution, and especially Article 38 on political rights, are in some way curtailed. In fact, one of the arguments was that the minute the President becomes President, he ceases to be a citizen. So I will address that. First of all, my lords and my ladies, it's important to note that under Article 19 of the Constitution, 19.3, the fundamental rights and freedoms in the Bill of Rights, which includes the political rights, belong to each individual and are not granted by the state. So that the rights that the President enjoys as a citizen are not rights that can be taken away from him, because they are rights that he has, the inherent rights. He was born with those rights. And it says those rights are subject only to limitations contemplated in this Constitution. And the question we ask in the decision of the Court of Appeal, or even the submissions by counsel, what are the limitations in the Constitution to the President's rights to participate in any initiative, including the popular initiative? What is the provision of law that limits it? And why this is critical, my lords, is that if you look at Article 24, which is the only one that deals with the limitation of rights, it says a right or fundamental freedom in the Bill of Rights shall not be limited except by law, which means there would be a law that then limits the President's rights, because there is no dispute that the President has the right to vote. Why would we take his political rights to participate in a political cause? Secondly, under Article 24, sub-Article 2, it says, my lords, that in the case of a provision enacted or amended after the effective date, the legislation is not effective unless it specifically mentions the intention to limit the right to a fundamental freedom and the nature and extent of the limitation. But more importantly, Article 24.3 says, the state or a person seeking to justify a particular limitation shall demonstrate to the court, the tribunal, or other authority that the requirement of this article have been satisfied. Meaning, the only way that the rights of the President to participate in the initiative or the process in Article 257, the only way they can be limited is that the person who is seeking that limitation must demonstrate compliance with the provisions of Article 24 of the Constitution. No such demonstration has been done by any of the parties or by the Court of Appeal itself. And so which are these rights that we are saying the President enjoys and that cannot be limited? The first one, my lord, is Article 32, which entitles the President or any citizen of this country to the freedom to thought, belief, and opinion. Secondly, my lord, the President has the right, under Article 33(1)(a), to seek, receive, or impart information or ideas. So that, my lord, as the example given by my learned senior, if the President would want to support the popular initiative or an idea to amend the Constitution, he has a right to impart those ideas. He's entitled. So if you are to take away that right, the only way you can do it is by showing that the provisions of Article 24 have been complied with. In this case, no such compliance has been demonstrated. Article 38, my lord, empowers the President or any other citizen of this country to campaign for a political party or cause, so that if the President has campaigned on a platform that entails amendment to the Constitution, he is entitled, my lords, to campaign for that cause. That right cannot be taken away from him just because he has been elected as the President. And so, my lord, just by the fact that he took an oath of office, he did not lose his rights and freedoms. And my lord, under in fact, one of the examples that is given, my lord, is that under Article 137 of the Constitution, it says that the only person who can vie for president, it must be a person who does not owe an allegiance to a foreign power. And therefore, that means that the president's right to participate, or rather the president's citizen rights have been curtailed to the extent to which he cannot have dual citizenship. First of all, that provision relates to qualification for election as president, but more importantly, even if it's a limitation, then it's a limitation that is contained in the Constitution, and that is permissible. My lord, the other issue is regarding the history that led to the promulgation of Article 257 of the Constitution. This has been referred to. But let me say this, my lords and my ladies. First of all, it's important to note that there is nothing like a universal constitution, meaning there are no boilerplate provisions for the enactment of the Constitution. A constitution, my lord, is dependent on the circumstances and the context of each country. And my lords, my learned friend, Mr. George Oraro, has gone through the history leading up to the enactment of Article 257 of the Constitution. And as he said, my lord, what it was meant to curtail is parliamentary dictatorship. There is a suggestion that this also meant the president's rights and powers are curtailed in some way. But my lord will notice that this is a reading into the report provisions that are not contained in that report itself. And the last question that I would want to ask, which my lord I think is pertinent on this issue, is while we are preoccupied, or the Court of Appeal was preoccupied with the question about him supporting an initiative, if a suggestion is made or a bill is introduced, for example, to reduce the boundaries of Kenya for any reason, can the president oppose it? And the simple answer must be yes. If the president feels that what is being suggested is inimical to the interests of the country, he has every right to oppose it. And if he can oppose, then surely he can propose. The last issue, my lords, that I need to talk about is the issue of whether the second schedule to the Constitution of Kenya was unconstitutional. You'll find this at paragraph 495A, Roman 12 of the lead judgment of His Lordship Justice Musinga of the Court of Appeal, where they upheld the findings of the High Court on this issue. We have addressed this issue at paragraph 66 to 92 of our submissions, and at paragraph 39 to 58 of our supplementary submissions. And it's a humble submission that the learned judges fell into error and misdirected themselves in making the determination that they did for the following reasons. One, my lords, it's a fact that a comparison between the provisions of the second schedule, of the Constitution of Kenya 2010 and the retired Constitution will show that under Section 42 of the retired Constitution, the Electoral Commission of Kenya was the one empowered to determine the number of constituencies and the demarcation of the boundaries. This power was taken away in the Constitution of Kenya 2010 at Article 89. Specifically, the power, my lords, to create new constituencies was taken away from the ECK. But what is critical for purposes of this discussion is that the fact that the number of constituencies and their distribution has a direct impact on the issue of fair representation and equality of the vote under Article 81 of the Constitution. In fact, in the revised report of the proposed boundaries of constituencies and wards, which was submitted by the IEBC to Parliament on the 9th of February 2012, it is document 1 in the second supplementary bundle of the Attorney General's second supplementary bundle of authorities. In the observations, which you'll find at page 36 of the bundle, one of the observations made was that the reports that were given by the people showed that they were influenced by the trend that resource allocation and access to government services is linked to electoral boundaries. And so, my lord, the observation with regard to representation, it was noted that the allocation of proportional representation had led to heightened interest for additional seats. And lastly, my lord, there was a comment that the distribution of constituencies had become such a critical matter for Kenyans. In fact, my lords and my ladies, the report by the Kriegler report, now referred to as the Kriegler report, 2008, you'll find this at page 76 of the report. It's page 3014, volume 21 of the first appellant's bundle of authorities. It noted that one of the causes of the violence in 2007-2008 was the issue of underrepresentation in Parliament. In fact, one of the points that they made at page 76 is that the weight of a vote cast in Lamu East was 18 times that of the vote in Embakasi, so that there was no equality of vote in, at the time that this report was written. And so the people deliberately removed the mandate of allocation of constituencies from commissions and reserved this for themselves. Why? Because the problem that was noted in the Kriegler report was brought about because the issue of constituencies was left entirely to the ECK, to an independent commission. And that is why it is necessary that when it comes to determination as to the number of constituencies and their distribution, it is a matter that can only be determined by the people themselves. My Lord, there is a suggestion that by this particular schedule suggesting the manner in which the constituencies will be done, that it amounted to dictating to IEBC how to carry out its mandate. My lords and my ladies will notice two things. First of all, the second schedule did not at all attempt to amend or delete any provisions of Article 89 of the Constitution. The provisions of Article 89 were left intact. The only thing that the second schedule said is that the population quota should be prioritized. My lords and my ladies, the prioritization of that particular requirement of the population quota cannot be said to amount to taking away or to taking over the role of IEBC. In fact, if you look at the second schedule itself, it requires IEBC to carry out its mandate of boundary delimitation, because that's the role that IEBC is supposed to play. The only thing that it was required is that in doing so, it must prioritize the population quota. And so, my lords, it's a humble submission that that particular schedule cannot be said to be unconstitutional because it did not place any restrictions on IEBC mandate in the manner that was suggested. My lords will notice that under Section 27 of the 6th schedule to the Constitution, in fact, what the people of Kenya had done in that case is that they had protected some 27 constituencies and said that when IEBC is carrying its work, it must not affect those constituencies, meaning that had it not been for that provision, those 27 constituencies would no longer be available. And so limitations on what the people require to be done, my Lord, cannot be said to be a taking away of the powers of IEBC. But there is a particular issue, my ladies and my lords, that I used to say before I sit down. In the report that I've just referred, my lords and my ladies, to, at page 36, there are observations by the Independent Electoral and Boundaries Commission, and there are about 6. My lord, the first one, which is the bullet point number 2, talks about members of the public were critical of the alteration of boundaries of constituencies and wards, even where the primary objective was to ensure compliance with constitutional parameters. In many cases, the public were unwilling to accept alteration of boundaries based on constitutional parameters. Then the next bullet point, electoral boundaries are delimited for the primary purpose of ensuring effective representation. However, there is a general perception that delimitation of boundaries is linked to resource allocation. Then finally, the next bullet point at the end, the last sentence, it says that the view about electoral boundaries was influenced. Government services is linked to administrative boundaries and electoral boundaries. And so, my lords, it says that they were making recommendations to Parliament in considering the report to address ways of ensuring conformity with the principles of representation as envisaged under the Constitution. So you can see that even the IEBC itself recognized that the issue of allocation of boundaries is such a political issue that the resolution of that issue can only be done through negotiations and compromises between the people. And this is exactly what the people did. They said there will be 80 additional constituencies, and they agreed on the distribution of these constituencies. My lord, that is a power that the people clearly have under the Constitution. And so, my lord, on that basis, we urge the court to find that the people in the exercise of their rights under the Constitution can direct IEBC on how to carry out its mandate. Now, my lords and my ladies, The issues that confronted the Court of Appeal required, my Lord, that the Court of Appeal would have regard, one, to the wording of the Constitution itself. It would have regard to the circumstances, which it's a very important issue. And the circumstances are contained in the reports that have been submitted to Parliament, and especially the Kriegler report, which specifically said that this issue about allocation or distribution of constituencies is a powder keg. It can lead to civil unrest in this country. And therefore, it cannot be that the people themselves, the best solution to it is to allow the people themselves to sit, discuss, negotiate, and agree on how these constituencies will be distributed so that it allows for a unified country. And so, my lords, we urge you to find that the finding of the court on these issues was erroneous and to allow the appeal as pleaded. I thank you, my ladies and my lords, for your patience, and I also thank my learned colleagues for contributing their time. Thank you.
Thank you very much. We'll now move to the second appellant. You have 1 hour between yourselves.
May it please you, Chief Justice and members of the court, I have already introduced my colleagues. We act for IEBC. 3 of us will be addressing you. That is myself, Mr. Eric Gumbo, and Mr. Justus Munyidia, in a manner that I will indicate shortly. We have filed various documents that have been identified in our written submissions. We have a record of appeal dated the 30th of September 2021. We have a supplementary record dated 14th October 2021. We have written submissions dated 25th November 2021. We have grounds of objection dated 28th September 2021. This being, my lords, in response to a petition of appeal by one Morara Omoke. We have supplementary submissions dated 10th January 2022. We have a digest of authorities dated 25th November 2021, and we have a supplementary digest dated 12th January 2021. My lords, this is a unique case, and it is particularly more unique for IEBC because the decisions rendered in the courts below have had the effect of declaring that IEBC operated for some time without quorum and therefore without constitutional authority. If that be true, the consequences of that finding would have very, very monumental consequences because IEBC has continued to conduct its work until the recent nomination of commissioners on the basis that it was properly constituted. We will be urging, my lords, that in considering this question of whether or not IEBC has at any time been improperly constituted, we will be asking the court to observe the principle of the restraint on the judicial power. We will be arguing in particular that there is reason for the court itself to realize the independence of other institutions created by the Constitution. That is a very fundamental submission for us, that the court ought at all material times to be conscious of the fact that the Constitution constitutes other independent bodies, and that the court's supervisory jurisdiction is not one that is not circumscribed by law, but indeed one that is seriously circumscribed by law in respect of the Committee of Institutions, that is the relationship between the judiciary and the executive, the relationship between the judiciary and the legislature, and the relationship between the judiciary and independent commissions. I think in the lower court we probably didn't express ourselves with sufficient clarity on this issue. It is not our submission that IEBC is not subject to judicial supervision by way of judicial review. It is our argument that IEBC is independent, equally independent constitutional institution, and there must be just cause. There must be just cause to interfere, and I use that word intentionally, to interfere with the exercise of that independent mandate. And I will be arguing that it is not for any other body to seek to review the mandate of IEBC on the basis of its own, that other body's own perception of what is reasonable or what is fair or what is convenient. Now let me get to the heart of our case. We will be making two broad arguments, and then we will be responding to Mr. Morara Omoke. The first argument, my lords, is as follows. The declaration of unconstitutionality of a statutory provision, such as was found in this case, has consequences other than those that the court purported to determine. Secondly, we will be arguing that a decision by a competent court in relation to the mandate and the composition of IEBC was a decision in rem, and had it been made by any other competent court, was not available to be overruled by a court of equal jurisdiction. My learned friend, Mr. Gumbo, will deal with the issue of public participation, and my learned friend, Mr. Munyidia, will deal with the purport of Article 257 of the Constitution. It is our submission that the question before the judges of appeal relating to quorum was not properly resolved by that court. And I refer you to Part 4 of our petition of appeal dated September 30th, 2021. We say this for three reasons. Why was the court in error in determining the question of the quorum of IEBC? First, the effect of a declaration of unconstitutionality is the subject provision ceased to have legal effect and cannot be placed reliance upon. If the court were to find that a court of competent jurisdiction found a statute to be unconstitutional, then that court must then further make the finding that those provisions ceased to exist and were of no legal effect. Secondly, we submit that when a court declares a law to be unconstitutional, that being a public law, Such declaration binds the parties before the court, the public at large, and other courts of concurrent jurisdiction. Thirdly, the decisions and actions flowing from the impugned statute being in rem cannot be illegal or invalid retrospectively, and we will explain why that cannot be. Now, let me come to the reason we say that the effect of declaration of unconstitutionality of paragraph 5 and 7 of the second schedule to the IEBC Act in the Katiba case had effects other than those attributed to it by the Superior Court. First, the learned judges of the High Court, that is where the original scene was planted, the learned judges of the High Court, and I say that with respect, misconstrued the relevant provisions of the law in relation to the question of the petitioner's quorum to conduct its business. And I refer you, my lords, to the High Court's decision at paragraph 702, 714, 719 of that judgment. And you'll find this at page 7137 of the record. From a reading of the High Court judgment and that of the Court of Appeal, both courts seemed to proceed on the understanding that paragraph 5 and 7 of the second schedule of the IEBC Act were alive and available for use in the dispute before them. It is our very humble submission. Section 5 and Section 7 had been declared unconstitutional and were now dead and unavailable for any use. Now, let me take you, my lords, through the reasoning. In the Katiba case, which is petition number 548 of 2017, authority number 1 in our bundle of documents, the court found that paragraph 5 and 7 of the second schedule were unconstitutional. As at the time we appeared before the High Court, that decision had been in existence for 37 months. As at the time we appeared before the Court of Appeal, it had been in existence for 41 months. It was a valid judgment, a valid decision. There had been no appeal. And that order had not been varied or set aside. So the finding of unconstitutionality of paragraph 5 and paragraph 7 of the second schedule had never been disturbed. The result, therefore, my lords, is both the High Court and the Court of Appeal relied on a repealed law, a law that was no longer in existence. And it is our very humble submission that that was an incurable defect in law. We submit that the effect of a declaration of unconstitutionality is that the subject provision of statute ceases to have legal effect and cannot be relied upon. In the Katiba case, my lords, I would not waste your time by rehashing it here. The court did not elaborate what was to be the effect of its declaration of unconstitutionality. But in our submissions, we have said that this court has pronounced itself on this point many times. What are the various permutations where the court finds unconstitutionality. And I will not repeat that for the benefit of time. But it is our submission that in the Katiba case, there was only one interpretation that would be logical. The declaration was prospective into the future. It could not have been retrospective, because again, this court has pronounced itself on the point, and that is to say that all acts rendered in good faith under the repealed law, under the impugned law, are sustained as legal if the finding of unconstitutionality is not retroactive. It is therefore our submission that that is a logical position that the court ought to continue to hold. Otherwise, the uncertainty of the law would bring chaos to the constitutional order. Let me revert to the case at hand. If paragraph 5 and 7 were no longer available, what then was the law on quorum? What then was the law on quorum? And we are saying there no longer was a specific law on quorum. And therefore, we would fall back to the provision of the Constitution on the constitutionality of the Commission itself. Let me give you a flavor very quickly of how challenging this issue was even to the Superior Court. The few judges who averted to it had very different views about what ought to happen. I draw your attention to the comments of the President of the Court of Appeal, Musinga J.A., at paragraph 359. His decision is at page 8306, volume 53 of our records. And he says, "It follows, therefore, where a court having declared a provision of a statute unconstitutional, but does not state the effective date of that declaration, the declaration becomes effective from the date of judgment, unless an appeal is preferred against the decision." We think that as a general proposition that is correct, except to add that even if an appeal is preferred and no order, no interim order is given, that becomes the ruling jurisprudence until the Superior Court has pronounced itself. To your JA, again at page 9145 of the record, which is volume 59, paragraph 125, says, "Where, however, a declaration by the court is silent as to when it shall take effect, the date of declaration is deemed to be the date of the effect." And that is the position we are urging this honorable court to take. The effective date becomes the date that that declaration was made. Now, there was, Tuyot J.A. made a very important observation that I would like to draw your attention to. And he says this: "An amendment of a statute is a legislative act, and while it is open to a court to declare an amendment to be unconstitutionally void, the declaration does not revive the former provisions." That is a very important point, my lords, and this is where the original error occurred. The High Court proceeded on the basis Section 5 and 7 were struck out. When they were struck out, the quorum provisions reverted to the status quo ante. It is our very humble submission. That cannot happen. And we are all familiar with the legislative process. When a bill to amend is presented to the House, it states paragraph this and this are deleted and substituted thereby by this one. Once the court finds that the deletion has created an unconstitutional, it cannot reinsert. Only a legislative act can reinsert. And that's what Tuyot JA is able to discern, and that is what would have assisted to. So, when then, now let me allude to the judgment of Cairo JA as well, because he helps us to capture this controversy. He stated this: the decision of the High Court in the Katiba case was silent on the effective date of declaration. Based on the decision of the Supreme Court, I take the view that the default position is that the declaration of unconstitutionality related back to when the unconstitutional provisions were enacted, with the result, in my respective view, that the status quo ante was restored. Therefore, the requirement of quorum was 5. And this is what we are saying with tremendous respect. This was the reasoning that took the court into error. And that the correct reasoning was the reasoning of Tuyot JA, that there was nothing to return to. Now, if there was nothing to return to, what should happen? Luckily for all of us, the Constitution at Article 250, sub-article 1, sets the minimum. It sets the minimum members you need in a commission, and there were 3. And IEBC at this point had 3. So it was not open to the court to find that IEBC was acting unconstitutionally. In fact, it was not open to the court to find that IEBC had no quorum, because to find that would have therefore to find that this institution did not comply with the Constitution, which wasn't true. The second point I want to argue, and I think I will be on my way, is that there existed a case in REM. There existed a case, the case of Biwott. I call it the Biwott case. Biwott versus IEBC. Biwott versus IEBC had made 2 critical findings. One, that the IEBC law contemplated vacancies in the commission, and 2, that the existence of a vacancy did not affect the constitutional functions of IEBC. Now, what do I want to submit about the Biwott case? Simply this: as long as the Biwott case existed, a decision in public law, in REM, it was not open to any other court in the High Court, a court of concurrent jurisdiction, to come to any other finding, or rather to purport to overrule that particular issue. In our view, we submit that a declaration by a superior court on an issue in REM alters the subject matter of the declaration. Remember this: from when the Biwott case was determined, every public official having anything to do with elections was now operating on the basis that this was the law. And my lords, let me remind you of another instance where I have appeared before you with the same problem. You will recall the 2017 presidential election. And you will recall there was the minor KI decision where the Court of Appeal, in its wisdom, had changed the jurisprudence of voting. And IEBC had changed all its procedures to obey the minor KI decision. Then when we came before you, questions arose whether the minor KI decision was actually sound law. But this court came to the conclusion that to the extent that there has to be consistent in jurisprudence, public officials who act on the basis of the law as pronounced by the court cannot thereafter be blamed for such action. The Biwott case remained the jurisprudence available to guide IEBC. It was a judgment in rem on a public law issue, and therefore the High Court, and I want to make this other slight point, sometimes we lay some premium on what we call the 3-court bench, the 5-court bench. In our jurisprudence, that is about numbers. It has absolutely no juridical value. The judgment of a single judge interpreting the Constitution has the same juridical value as the judgment of 5 judges. That is our submission. And therefore, the way the High Court dismissed and swept away the Biwott case was unprecedented in our jurisprudence and was wrong. And it is therefore our submission that this court be persuaded to the position that the court acted in error. We have referred you, my lords, to the Canadian case of the Supreme Court of Canada, to the English case of Ems versus Queen, and I don't want to go through them because they will just take time. So, what then is my final submission before I call my learned colleague? IBC was always properly constituted. It had the quorum mandated by the Constitution itself. There can be no higher law than the Constitution itself. The High Court and the Court of Appeal were in error. The High Court and the Court of Appeal were in error in arriving at a contrary position, and the High Court and the Court of Appeal were in error in disregarding the effect of an existing judgment in rem in a matter of public law. I thank you, and I call my friend Mr. Eric Gumbo.
Good afternoon, my ladies and my lords. My name is Eric Gumbo, and with your permission, I'll take a few of your moments this afternoon to just share a few reflections in relation to one or two items on the question of the effect of a decision rendered in rem on a public law question. My lords and my ladies, I would want to take a moment to look at how the Court of Appeal addressed the issue that was presented before them. The primary issue being, how should courts of coordinate jurisdiction deal with decisions emanating from within their ranks? In other words, is the doctrine of stare decisis binding horizontally on those courts that exercise coordinate jurisdiction? My ladies and my lords, I would want to perhaps take a moment to look at what the Court of Appeal had to say in relation to this question. So generally, only one judge addressed this issue, which we consider to be very fundamental. Justice Tuyot appears to be the only one who took time to render himself on this question of the effect of a decision rendered in rem on a public law question. His decision, in particular, at paragraphs 131 to 137, attempts to deal with the issue in detail. And so in discussing 2 or 3 issues in relation to that question, I would want to quickly make a point that at paragraph 131, Justice Francis Stewart agrees with the argument that indeed the decision in Isaiah B. Ward Kangwon was a decision in rem on a public law question. He then proceeds to ask the question as to whether that decision is supposed to be binding. And so he says, as in passing, that one would actually be sympathetic with the IEBC if it were to, on the strength of a decision, take comfort that it had the required constitutional capacity to discharge its mandate. Justice Stewart then goes on to say, and this is, I think, very important, that inconsistency in pronouncements of courts in the area of public law confuses members of the public as to what the law is and is a recipe for judicial anarchy and mayhem in public law. I think, my lords and my ladies, that really will be the gist of what we'll be looking at this afternoon. Justice Stewart, if you permit me, I would read just one paragraph, says, the law, particularly in matters touching on the public, cannot be minimized. Both the public and the person or bodies charged with carrying out public functions should be able to tell without difficulty, hesitation, whether their actions or conduct passes legal or constitutional muster. To hold that a public body is properly and legally constituted today and to say otherwise the next day may not be good for public administration. So there is much to be gained in legal stability that is brought by stare decisis. My lords and my ladies, permit me to just make a comment to emphasize on how important that issue is. Article 159 of our Constitution makes or invites courts, when exercising judicial authority, to then promote the principles and values of the Constitution. In particular, where then do we find these values in the Constitution? My lords and my ladies, Article 10, specifically, Article 10, Subarticle 2, sets out the importance of the rule of law. Let me then quickly move to Article 259. My lords and my ladies, Article 259 of our Constitution speaks to the manner in which the Constitution is supposed to be construed. It says, my lord, a number of issues that are supposed to be looked at is, one, that the Constitution is supposed to be interpreted in a manner that, first, promotes the values and the principles of the Constitution. Again, one of the values of the principles of the Constitution is the rule of law. Then secondly, that in construing the Constitution, my lords and my ladies, again, it should be construed in a manner that advances the rule of law. Why then is this important? It is important, my lords and my ladies, because when, in fact, we could not even get into discussing the Constitution itself if we don't give credence or prominence to the fact of the rule of law. And so what then is the rule of law? My lords and my ladies, we would want to make the submission that the rule of law has certain essential features. One of the fundamental essential features of the rule of law is that it must be stable, it must be clear, and it must be certain. And where it is applied, my lords and my ladies, I would want to add that it must be applied evenly. This, my lords and my ladies, is what has been contained in the principle of certainty of legal certainty in constitutional and even legislative interpretations. My lords and my ladies, what then are we saying of conflicting decisions? There's been finding in, I think, in relation to Section 63 of the Finance Act. The High Court made a finding that that section was declared unconstitutional for being vague. What then do we borrow from this? It means, my lords and my ladies, that if we can interpret an act of parliament for being, as being unconstitutional for being vague, what then does it say of conflicting decisions? And examples would be, my lords and my ladies, if today, and there's a live issue, there's a live question on this, there's a question about whether public officers are supposed to resign 6 months before the general election if they want to exercise their Article 38 rights. There's been two conflicting decisions on that issue. One judge says that, oh yes, indeed, you must resign 6 months before the general elections. Yet on the same question, another judge on concurrent jurisdiction says, no, it is not a must for you to resign. So, my lords and my ladies, if this question was to be brought before a public agency like the IEBC, what would be the position in relation to that question? So it then is our submission that for us to say that we have given credence to the doctrine of the rule of law, then that rule of law must be certain. It must be such that one can be able to determine what the rule is or what the law is at any one point in time. I'll give another example, my lords and my ladies, in relation to Section 42 of the Employment Act and how courts have treated disputes arising from employees who are still on probationary contract. One court says that Section 42 is unconstitutional to the extent that it requires, or rather it denies such employees the opportunity to be given a fair hearing. Another court says, no, there's nothing absolutely unconstitutional in relation to that issue. So I'm using this, my lords and my ladies, just as an example to be able to demonstrate the significance of the fact of the rule of law. My lords and my ladies, that aside, if we don't have consistency on the rule of law, what would we be doing to the question of the doctrine of precedent? What would I be doing to a magistrate sitting in a place like Ortum when I appear before them and I have two decisions? On the one hand, I tell them, in relation to the question that you want to interpret, the High Court has said this. Then my colleague, maybe counterpart appearing on the other side, says, no, in relation to that question, the same court has said this. This really is the gravamen of our argument. We will be submitting later in the course of my submissions that in relation to public law matters, my lords and my ladies, there should be, the doctrine of stare decisis should and must be applied to be binding, at least horizontally. And I'll take a moment to be able to just demonstrate why we take that position. My lords and my ladies, this issue of the constitutional significance is an issue that has also received consideration before yourselves. And I remember, if my memory serves me right, Lady Justice Njoki Ndung'u, in Evans Odhiambo Kidero in 2014, versus where, that is Evans Odhiambo Kidero versus Fiden and Waititu, and it's a decision we've cited. In her concurring judgment, she speaks with, in relation to the question of the rule of law and the need for certainty on the question of the rule of law. So, my lords and my ladies, that is how important that question is to us. That when Justice Wilfrida Okwany had, on the one hand, told the IBC that you have the necessary constitutional capacity to discharge your duties, then they were perfectly in order to rely on that decision. And that for purposes of good order and consistency in the law, it was then not available for courts of coordinate jurisdiction to come in and say, no, wait a minute, that first court was wrong on that question. I'll take a few moments to just examine how that then should be dealt with when a court is faced with that situation. My lords and my ladies, I want to revert back to how Justice Francis Tuyot then resolves this controversy. At paragraph 137, Justice Francis Tuyot refers or relies on a persuasive decision from Canada, that is from the Court of Appeal in Canada. That is a decision in R versus Sullivan. We provided that decision as part of a bundle of authorities. And my lords and my ladies, in that decision, the judge of appeal, one of the judges called Judge Pasicchio, then says that in his opinion, the doctrine of stare decisis does not apply any differently, even in public law questions. I'll take then a moment to look at how Justice Francis Tuyot then proposes that we deal with this issue. He says on the one hand at paragraph 37 that even in public law issues based on that reasoning of R versus Sullivan should be applied in the usual manner, meaning that courts are ordinarily not bound, but they need to be reluctant to unsettle the law in relation to a question where there has been a finding, unless there is overwhelming persuasion that they would want to depart from that decision. It then adds on to say that when faced with those sort of situations, the AG and the public body in issue then should be invited to be able to share their comments or their views in relation to that issue. And the most important part is, it then says, if the earlier decision is on appeal, then the latter decision is supposed to await the outcome of the appeal. My lords and my ladies, maybe let me share two or so reflections on that question, just as I conclude that question of the effect in rem of a decision in rem. One, we have always applied that decision with the flexibility that courts of concurrent jurisdiction can depart. But what have we seen? We've seen a situation where that reluctance to depart, which Justice Tuyot proposes, in practical sense, has never quite been applied by the judges. And so we have seen a result where, because there's been no reluctance, then we have been seeing conflicting decisions. In any event, then putting, just looking at the decision in R versus Sullivan, Justice Pacheco himself says that even in Canada, that issue has never quite been settled. And specifically, I'll refer you to paragraph 33 and 36, where he makes reference to another decision, again, of a Court of Appeal in R versus Butelier, where he says the Court of Appeal in that other decision made a finding that when faced with a public law question, then courts of horizontal jurisdiction, that is coordinate jurisdiction, are supposed to be bound. And so then what then is our proposal as to how this question can be resolved? My lords and my ladies, we propose that this court can examine this issue and make a general proposition or binding proposition that in relation to public law questions, then the stare decisis principle is binding on courts of coordinate jurisdiction. I then ask myself, how then will this be applied in questions or in cases where a judge is persuaded that they need to depart? And in that, my lords and my ladies, I ask that then we look at a possibility of having what I would call a leapfrog appeal. And a leapfrog appeal is not a new phenomenon in our legal parlance. My lords and my ladies, we can have a situation where the subsequent court in departing can then first frame the issue, the public law question, rationalize their decision as to why they want to depart, and then have the parties appear against to the Supreme Court directly, so that then the Supreme Court can resolve that issue with finality. My lords and my ladies, this is not anything that will be new, because Section 17 of the Supreme Court Act permits for direct appeals to the Supreme Court. And Section 16 then presupposes that one of the conditions that one would need to meet if the court is supposed to, if the Supreme Court is supposed to entertain that issue, is that it must be a question of general public significance. And so nothing stops us. And it is not a unique thing. This has been done in the US, it has been done in the UK, and for the first time, perhaps, my lords and my ladies, we would then want to rely on Article 159(2)(d), where we say technicalities of procedure in any event should not be a reason why an appropriate and effective remedy should not be proposed or applied by a court. In fact, in the UK, they've gone further to even then have it in the statute book, so that Regulation 6.1 of the House of Lords Practice Directions provides for leapfrog appeals. My lords and my ladies, nothing stops this court from making that binding proposition, so that then we will have a situation where a judge would either be bound, and if they want to depart, then they would make reference to rationalize their reasons for departing, but have the Supreme Court make a final and binding position in relation to that issue. My lords and my ladies, my time is running. Let me quickly then move to the question of first, just before I get there, what then should have been the appropriate remedies? And this is important, my lords and my ladies, because the IEBC relied on the decision in Kangwon for the time that it was valid. They made certain very far-reaching decisions. They had the election operations plan, which, my lords, is a very, very significant instrument for purposes of managing elections, particularly the 2022 elections. So if one then was to argue that that document, which they have relied on substantively for carrying out a number of their activities, what then would be the place of the decisions that they've taken? Because you cannot say that they didn't have quorum for purposes of the referendum, but they had quorum for anything else. If we, my lords, do not then circumscribe or protect what was done during the pendency of that position, then even the 2022 elections would be placed in jeopardy. And that, my lords and my ladies, is not a position that the court would want to put, or one would want to have the country in at this point in time. My lords and my ladies, on the question of mandate of the IEBC, in relation to specifically Article 257, my lords and my ladies, it is our submission that Article 257 creates specific actors, and for each of those actors, it creates a specific obligation. Now, in issue today is Article 257(4). My lords and my ladies, Article 257(4) in relation to the mandate of IEBC. My lords and my ladies, what then is our pain point in relation to the findings from the High Court and the Court of Appeal in relation to this issue? Two things. The High Court at paragraph 577 of their decision, and this is to be found at page 70, that is 7087 of volume 47 of our record, makes a finding that the IEBC ought to have satisfied itself that the promoters of the initiative had conducted public participation. And so the quick things that we want to say in relation to that, my lords, is one, what test is to be applied in that case for IEBC to be able to determine that the promoters have done an efficient and effective public participation? My lords and my ladies, it must be an objective inquiry. Who will be the complainant? Who will make the determination? Are we seeing a situation where we'll be asking the IEBC to be a judge in its own cause? My lords and my ladies, that is a question which, in our humble submissions, is supposed to be left to the High Court under the jurisdiction of the High Court in Article 165 3D2. That is, to make an inquiry as to whether anything done under the authority of the Constitution is consistent with the Constitution. And on that, my lords and my ladies, there is a decision from Justice Nyamoya in the case of Republic versus County Government of Kirinyaga ex parte Kenda Muriuki, where the learned judge says that in relation to the question of public participation, one would have to wait until the entire process is completed for them to be able to ascertain whether or not there was an effective public participation. So, my lords and my ladies, another thing in relation to that, why the IEBC cannot be the one to then make that determination. Would IEBC not be fomenting a course of action against itself if it were to hold that a party who otherwise qualifies, who otherwise has met the criteria for 1 million registered voters for purposes of a constitutional review initiative, is returned only because of the fact of not having demonstrated public participation? IEBC might not have that capacity. That is the first concern. We raise that as an area, as a pain point, because it is an issue that does not flow from the text of Article 257(4). But, my lords and my ladies, the learned judges of the Court of Appeal did not make a finding on that question. In fact, and this brings me to the second issue, the learned judges of the Court of Appeal made a more onerous pronouncement on that question of public participation in relation to the IEBC. What do they say? Justice Gatembu Kairu, at paragraph 90 and 91 of this decision, says that in fact it is the IEBC that is supposed to be conducting that public participation. My lords and my ladies, I think that, again, with respect, is a decision made in error, because the text and even context of Article 257(4) does not place that obligation on the IEBC. And I'll demonstrate in 1 minute or so. That's why IEBC cannot be able to discharge that duty. It should not be forgotten that when the review process ultimately ends up in a referendum, then it is expected that it is the IEBC which will be conducting that referendum. What then would be the position when IEBC, in the course of conducting the referendum, would have also taken it upon itself to be the one to speak about the pros and the cons of the bill? Would we not be seeing a situation where there's conflict on this this institution that is supposed to be independent and impartial? My lords and my ladies, there are instances where the proposal itself would be on the IEBC. If a Kenyan today decides to move a motion to have the IEBC disbanded, then you tell the IEBC that you are the one to sensitize Kenyans on the pros and cons of disbanding you. I think that is not a position that would be tenable in law. My lords and my ladies, that said, what then should be the proper position of public participation? And the IEBC's position is that, yes, public participation is a very fundamental feature of constitutional review. It gives the people the opportunity to participate. What then should be the structure that this public participation should take? My lords and my ladies, I've read through the decision rendered by both the High Court and the Court of Appeal, but with respect, I don't seem to have gotten a place where the judges applied themselves as to how they should apply, as to how public participation is to be achieved. And if you permit me, I'll just take one moment to then, from the perspective of IEBC, share how this is supposed to be achieved. Article 257(5) presupposes that once the IEBC has verified that the initiative is supported by 1 million registered voters, it is supposed to forward the bill to the county assemblies. We then ask ourselves, why should they forward this bill to the county assemblies? My lords and my ladies, permit me to draw your attention to the provisions of Chapter 11 of our Constitution, specifically Article 174C. It speaks, my lords and my ladies, to the fact of the significance of devolution in this country. specifically that it gives Kenyans an opportunity to be able to determine their destiny, to be able to determine how they are governed. How then is that Article 174C given effect? My lords and my ladies, we've had the County Governments Act. One takes an opportunity to look at the County Government Acts, and my lords and my ladies, the fact of public participation is achieved in such a granular sense. Such a granular sense because the object one is to be able to give the citizens of every county assembly an opportunity to participate in the issues of the day. It, at Section 9, also makes provision, my lords and my ladies, as to how the MCAs are supposed to interact with the people in their county assemblies. More importantly, at Part 8 of that Act, there's a whole section that is dedicated to public participation. My lords and my ladies, it is even granular to the point of saying the languages, I mean, the public participation would be in, local languages and all that. So that gives an opportunity to have a meaningful interaction as public participation at that county assembly level. Now look at again the provisions of 196, Article 196 of the Constitution. That article, my lords and my ladies, provides that the proceedings of the county assembly shall be in public and that the county assembly shall facilitate that public participation. So a consistent and holistic reading of the Constitution then places the fact of public participation in that particular line. Now, that said, my lords and my ladies, in relation to the National Assembly, how do we achieve the fact of public participation? Article 94 and 95 of our Constitution speak to the role of the National Assembly. One of them is representation of the people, and it speaks to representation of the people from a delegated sovereign authority perspective. When you get a moment, you'll then appreciate that one of the critical functions, and I think that is Article 94, Subarticle 2, is to allow the delegated authority to be able to even make recommendations in relation to amendments to the Constitution. That speaks to the nature of the amendments that we are currently dealing with. My lords and my ladies, again, Article 118 of the Constitution then requires that proceedings in Parliament shall be in public. And my lords and my ladies, to then facilitate that, Standing Order number 127.3 of Parliamentary Standing Orders then dictates how that public participation is supposed to be done. It is in the form of the Member of Parliament interacting with the people directly. They could issue memorandum. And at that national level, my lords and my ladies, then the member of the National Assembly then speaks on behalf of the people. And why do I say speaks on behalf of the people? I get that comfort in Article 1 of our Constitution. Article 1 of our Constitution, my lords and my ladies, speaks to the sovereignty of a Kenyan. And so it says that the sovereignty shall be exercised either directly or indirectly through our democratically elected leaders. It then says that it then identifies at Subarticle 2 the delegated, where the delegated sovereignty is to be exercised. And that is in Parliament, and again in the executive, and even in the judiciary. My lords and my ladies, Article 1, Subarticle 3 then says that sovereignty shall be exercised at national and county levels. If we take that holistic reading of the Constitution, then we'll be able to place the fact of public participation where it is supposed to be placed. It is my submission this afternoon that if we for one moment conflate any component of the structure or the architecture of our constitutional review, then my lords and my ladies will run into the difficulty that we are seeing, and which then was not resolved by the learned judges of the Court of Appeal or of the High Court. With that, my lords and my ladies, permit me to stop at that to call Professor Githu Muigai to just give our ask of the court in relation to those matters. I'm most obliged.
My lords, following those submissions, it is our request that you grant our appeal and that you determine that IEBC at all material times had quorum because there was no operative law governing the question of quorum, and there was a definitive finding of the High Court resolving the matter. Secondly, we invite the court to find that that part of the judgment and the decree which determine that the petitioner is obligated to confirm that public participation is undertaken by the promoters of a popular initiative is set aside. Thirdly, we invite the court to declare that a decision in rem by a court of competent jurisdiction in relation to a public law question provides authoritative guidance until an appellate court pronounces itself on the matter. And finally, my lords, a declaration that the actions undertaken by the petitioner, relying on the decision of Isaiah B. Watt versus the Independent Electoral and Boundaries Commission, are legally valid and constitutionally sound. In the alternative, my lords, you may grant a declaration that the findings in relation to the question of quorum be circumscribed to exclude all acts undertaken in the currency of the decision of the Isaiah B. Watt case. Those are our humble prayers, and we thank you for according us the audience. We believe, my lady, subject to your clarification otherwise, that we will have an opportunity to use the 5 minutes we have left to reply to Morara Omoke once he has made his case. Thank you.
Yeah, thank you for the submissions. I was consulting on whether we need a break, a lunch break, and we do. Speak to the mic. Yeah, yeah. So we will rise and resume at 2 p.m. We take a break of 1 hour and 15 minutes.